Namaskar. Executive of the states, the governor. The governor of a state is appointed by the president and holds office at the pleasure of the president. Qualification for the post of governor should be a citizen of India, should be over 35 years of age, must not hold other office of profit, and should not be a member of the legislature of the union or of any state. Reference Article 158. If a member of a legislature is appointed governor, he is registered to be a member immediately upon such appointment. The normal term of a governor's office is 5 years, but it may be terminated earlier by the dismissal by the president. Reference Article 156(1). Resignation Article 156(2). There is no bar to a person being appointed governor more than once. Why an appointed governor? Because it would save the country from the evil consequences of still another election done on a personal issue. The governor is elected by the direct vote, then he might consider himself superior to the chief minister, leading to friction between the two. The expenses involved and the elaborate machinery of the election would not match the power of would not match the power of the expenses involved in the elaborate machinery of election would not match the power of governor. A second-rate man of the party may get elected as a governor, though an appointed governor, the union government can maintain its control over the state. The method of election may encourage separatist tendencies. Powers of governor. The governor has no the governor has no diplomatic or military power like president, but he has executive, legislative, and judicial powers analogous to those of the president. Executive governor has the power to appoint council of ministers, advocate general, and the members of the state public service commission. The minister as well as the advocate general hold office during the pleasure of the governor, but the members of the State Public Service Commission can be removed only by the President on the report of the Supreme Court, and in some cases on the happening of certain disqualification. Reference Article 370. The Governor has no power to appoint judge of the State High Court, but he is entitled to be consulted by the President in the matter. Reference Article 271. Like the President, the Governor has the power to nominate members of the Anglo-Indian community to the Legislative Assembly of each state. To the Legislative Council, the Governor can nominate person having special knowledge or special practical experience in literature, science, art, cooperative movement, and social service. Reference Article 171(5). Cooperative movement is not included in the corresponding list of Rajya Sabha. Legislative Governor is go, go, Governor is a part of the state legislature, and he has the right of addressing and sending messages, of summoning and proroguing and dissolving the state assembly judiciary. The governor has the power to grant pardon, reprieve, respite, or remissions, etc. of punishment. Reference Article 161. Emergency. The governor has no emergency powers to counter external aggression or armed rebellion. He has the power to report the president if government of the state cannot be carried on in accordance with the constitution. Reference Article 356. Chief Minister and the State Council of Ministers. The Chief Minister is the head of the State Council of Ministers. The Chief Minister is appointed by the governor. The other member ministers are appointed by the governor on the advice of Chief Minister. Any person may be appointed a minister, but he must become a member of the legislature within 6 months of such appointment. The Council of Ministers is collectively responsible to the Legislative Assembly of the state, but individually responsible to the governor. The relation between the governor and his minister is similar to that between the president and his minister. That discretionary function of the governor. The function which is specially required by the constitution to be exercised by the governor in his discretion are: the governor of Assam can determine the amount payable by the state of Assam to the district councils as royalty accruing from licenses for minerals, where a governor is appointed an administrator of adjoining union territory. He he can function as such administrator independently of his council of ministers. The president may direct the governor of Maharashtra or Gujarat shall have a special responsibility for taking steps for the development of Vidarbha and Saurashtra. The governor of Nagaland has similar special responsibility with respect to law and order in that state. The governor of Manipur has a special responsibility to secure the proper functioning of the Committee of Legislative Assembly, consisting of the members selected from the hill areas of that state. Governor of Sikkim has a special responsibility for peace and equitable arrangement for ensuring social and economic advancement. The governor has the power to dismiss an individual minister at any time. The governor can dismiss the council of ministers or the chief minister Only when the Council of Ministers has lost confidence of the Legislative Assembly and the governor does not think if it to dissolve the assembly, the governor of Assam can determine the amount payable by the state of Assam to district council as royalty accruing from the licensage of for minerals. The Advocate General. Each state has an Advocate General, an official corresponding to the Attorney General of India and having similar function for the state. He is appointed by the governor of the state and holds office during the pleasure of the governor. Only a person who is qualified to be a judge of the High Court can be appointed Advocate General. He receives such remuneration as the governor may determine. He has the right to speak and to take part in the proceedings of, but no right to vote in the houses of the legislature of the state. Reference Article 177. The state legislature. Some states have bicameral legislature having two houses. The 7 states having two houses are Andhra Pradesh, Telangana, Bihar, Karnataka, Maharashtra, Uttar Pradesh, and Jammu and Kashmir. In the remaining states, the legislature is unicameral and has the legislative assembly only. For creation, for creation or evolution of legislative council, the legislative assembly of the state should pass a resolution by a special majority followed by an act of parliament. Reference Article 169. The size of the legislative council may vary, but its membership should not be more than one-third of the membership of the legislative council. Legislative assembly, but not less than 40. Legislative council is a partly nominated and partly elected. Election to the legislative council is indirect and in accordance with the proportional representation by single transferable vote. Five, 5/6 of the total number of members of the council is directly elected, and its 1/6 is nominated by the governor. Indirectly, and 1/6 is nominated by the governor. One-third of the total members of the council is elected by local bodies such as municipalities, district bodies. Boards 112 is elected by graduates of 3 years standing residing in the state. 112 is elected by teachers of secondary schools or higher educational institutions. One-third is elected by the members of the Legislative Assembly from amongst persons who are not members of the Assembly. The remainder is nominated by the governor from persons who specialize in literature, science, art, cooperative movement, and social service. The court cannot question the bona fides or property of governor's nomination in any case. The Legislative Assembly of each state is directly elected on the basis of the adult suffrage from territorial constituencies. The total number of members of the Assembly cannot be more than 500 or not less than 16. The Assembly in Mizoram and Goa have only 40 members each, while the Assembly in Sikkim has only 32. Governor can nominate one member of the Anglo-Indian community in the Assembly. Reference Article 333. Duration of the Legislative Assembly is 5 years. It may be resolved as sooner than 5 years by the governor. The term of 5 years may be extended by the Parliament in case of a proclamation of emergency by the President for not more than 1 year at a time. Reference Article 172. 1. Legislative Council Vidhan Parishad is a permanent body like the Council of State Rajya Sabha. The Legislative Council is not dissolved. One-third of the members of the Legislative Council retired on the expiry of every second year. Reference Article 172. The Legislative Assembly has its Speaker, Deputy Speaker, and the Legislative Council has its Chairman, Deputy Chairman, and the provision relating to and provisions relating to them are analogous to those relating to the corresponding officers of the Union Parliament. Qualification for membership of the state legislature should be citizen of India for legislative assembly not less than 35 years of age. 25 years of age for legislative council not less than 30 years of age. Should possess other qualifications prescribed prescribed in that behalf by or under any law made by Parliament. Should possess other qualifications prescribed in that behalf by or under any law made by Parliament. Composition of legislative Seven seats are sorry. Comparison of legislative procedures between bicameral state legislature and parliament. For money bill, the position is the same. For other bill on the bills, the only for other bills, the only power of council is to interpose a delay of 3 months. In case of disagreement, the bill is second time referred to the legislative council, and this time the council has no power to withhold the bill for more than 6 months, more than a month. Reference Article 197 to be Governor's power of veto. When a bill is presented before the governor after it is approved by the House of the Legislature, the governor can declare resistance to the bill. In that case, it would become law. It must declare that he withholds resistance to the bill. Such a bill fails to become a law. Declare that he withholds resistance to the bill other than a money bill, and the bill is returned with the premise reserve a bill for the constitution of the reserve a bill for the constitution of the president. Such reserving is compulsory when the law is in question. Would, would derogate the power of the High Court. Power of governor to promulgate ordinances. The governor can promulgate ordinances only when the legislature of both houses are not in session. It must be exercised with the aid and advice of the Council of Ministers. The ordinance must be laid before the state legislature when it reassembles. Any ordinance is to have effect after 6 weeks from the date of reassembly unless approved earlier by that legislature. The governor himself is competent to withdraw the ordinance at any time. The scope of the ordinance promulgating powers of governor is confined to the subject in list 2nd, 3rd of the 7th schedule. Governor cannot promulgate ordinances without instruction from the President. If a bill containing the same provision would require previous sanction of the President, bill is required to be reserved for the consideration of the President. Privilege of the state legislature. Privilege of a state legislature are similar to those of the Union Parliament. Each house of the state legislature can punish for breach of privilege. Each house of the state legislature can punish for breach of its privilege or for contempt. Each house is the sole judge of the question whether any of its privilege has been each house is the sole judge of the question whether any of its privilege has been infringed. Court has no jurisdiction to interfere with the decision of the house on this point. No house of the legislature can create any new privilege for itself. No house of legislature no house of legislature can create any privilege for itself. Court can determine whether the house possesses a particular privilege. No house of the legislature can create any new privilege for itself. Court determine whether the house possesses a particular privilege.